Yes, sir.
All right. Then we're ready to proceed. I'm going to, even though this was initially begun as a child support matter and Ms. Hewitt was listed as the plaintiff, the matters that we now are dealing with are all brought by your client. So we're going to allow your client to have the first say in the matter. He'll proceed. He'll have the burden to show what needs to be done in the case. So, Ms. Hendrickson, do you wish to make an opening statement? All right. The case that's going to be heard will require testimony, and as a result, if you are going to be a witness for either side in this case, you must go outside of the courtroom and remain outside of the courtroom until you're called to testify. You are prohibited from discussing the testimony of any other witness with anyone or from watching the proceedings which are being live streamed on YouTube, and violation of that order would not only constitute contempt of court, but it would bar you from testifying. All right. If you're a witness, you must go outside. You have witnesses that need to go out?
Judge, I would request the 12-year-old Miss Sophie also. I'm not sure if she's going to be called to testify.
Not testifying.
All right, guys, listen up. The judge wastes no time setting the tone. What started as a simple child support case just turned into a full-on parenting rights battle. The courtroom is tense as he reminds everyone this isn't about excuses anymore, it's about facts and responsibility. Witnesses are warned, emotions are high, and the mother looks uneasy. The judge makes it crystal clear anyone caught breaking his order will face contempt. The audience already feels that this hearing is about to get serious.
That's fine.
So whoever's in this courtroom is not going to be prohibited, is not going to be allowed to testify unless they're a party at this point. So.
Judge, just to clarify, the contempt actions that we filed previously, those have been dealt with. So the only thing that's before the court is basically the final hearing, the establishment of parenting plan. And so I'm hoping that it will not take very long today. And so just a brief procedural history, since this case has been going on since last year. As you've stated, Judge, back in March of 2024, my client has filed a petition for paternity in response to a child support action that was filed against him where he was ordered to pay $800 per month. In May of 2024, he was confirmed as a biological father following a DNA testing. And then in July 8 of 2024, he filed a motion for a temporary parenting plan on the basis that Ms. Hewitt was not being cooperative with visitation time with him. And that was heard August 31st of 2024, where Your Honor ordered supervision at the mother's home. And I believe that this was largely based on the fact that the mother claimed that the child had medical issues, heart condition.
Hold on, because the father's attorney jumps right in, laying out the whole messy timeline like a pro. She reminds the court that her client's been fighting since early 2024 proving paternity, paying $800 a month and still being denied fair visitation. She details how the mother claimed medical issues, nonverbal autism, and heart problems to block visits. Guys, this is courtroom chess at its finest. Every word is a move. The judge listens closely, eyes narrowing. You can already sense he's doubting the mother's credibility.
Nonverbal autism and things of that nature, and so you were not comfortable with father having unsupervised visitation at that point. And so father attempted to have visitation from August 31 all the way to November 19 when I was hired in this case. From August to November, father had difficulties with this supervised visitation, resulting in us filing for contempt actions and motion for Christmas visitation. That was heard November 19, and Your Honor did allow my client to have unsupervised visitation overnight. That was for the Christmas time, but kept the same visitation for my client. And that day also, the mother maintained all of her claims that the child had some rare condition. He was going to therapy throughout the week. He was getting speech, OT, ADA, physical therapy. And so based on that, again, my client stayed in that same visitation. And so then we fast forward to January.
Alright guys, this part hits hard. The attorney explains how, back in 2024, supervised visitation was ordered only at the mother's home. She paints a picture of a father trying, week after week, to see his son and getting stonewalled every single time. When Christmas came, the judge finally allowed one overnight visit, but instead of cooperating, the mom doubled down, pushing her story of endless therapy sessions and rare conditions. The courtroom can feel the frustration. The father's patience has clearly run out.
January 29. At that time, I had subpoenaed all of the medical records and the TEIS, the Tennessee Early Intervention records, and the school records. And we had a hearing January 2029, resulting from our motion to appoint my client as a temporary parent, primary residential parent. At that point, we were so concerned of what we found. And in that hearing, Judge, you did found that Mrs. Hewitt had delayed access to certain services with TEIS for about a year, physical therapy, speech therapy, developmental therapy. There was an ophthalmology consult that was not done for months. Ashton had a cardiology appointment that was not done. Well, baby checkup, and that's in the order, Judge. And so at that point, Your Honor did not find that Ms. Hewitt was credible in her testimony, and you appointed my client as the temporary primary residential parent, and then awarded Ms. Hewitt a weekend visitation, and the child support was suspended at that time. February 25 of 2025 of this year, Ms. Hewitt then hired an attorney. We had to file a...
Things heat up as the lawyer reveals what happened next. She subpoenaed medical and school records, and boom, the truth exploded. The judge found the mom had delayed therapy, skipped appointments, and misled T's for months. That's right, guys. The so-called medical excuses were falling apart. The judge had enough and named the father temporary primary parent. The mother lost credibility right there in front of everyone. This wasn't just a win, it was a total courtroom takedown.
Second, criminal contempt, because at that point, your order was for Ms. Hewitt to return the child after her visitation to Mr. Fenton. And by May 14 of 2025, you heard two motions, actually three motions, all of my contempt motions, and Ms. Hewitt's motion to reconsider the January 29, 2025 motion. You denied that motion to reconsider, and then you found Ms. Hewitt guilty of 2 counts of criminal contempt, specifically. That was 2 days in February where she refused to return the child. And you had suspended the 20 days of incarceration at that point. And then you also, Judge, modified the pickup time from 2 4 p.m. And my client was supposed to pick up. So that way we prevent, further issues. And then also on that day, we were supposed to be heard on this motion for the permanent parenting plan. But because Your Honor was considering the fact that the lawyer was just hired that time, that you were giving him some time to get acclimated with the case, you continued that, and then here we are today.
Fast forward to 2025, and the chaos continues. The mom refuses to return the child twice. The court slams her with 2 criminal contempt charges and even threatens jail time. 20 days suspended, but the warning is loud and clear. The judge modifies pickup times so the father isn't played again. Guys, you can practically feel the tension rising. Every line from the judge hits like a hammer. This mother's pattern of defiance is catching up, and fast.
And so, Judge, our goal is to finalize this case and finalize the parenting plan. And also, Ms. Hewitt, obviously, his lawyer had withdrawn by July of 2025. It's been well over the 30-day period that you gave her, so she hasn't hired a lawyer, obviously. We had filed a proposed permanent parenting plan initially, but that has now changed, and so I am going to present an amended one just based on the recent events that happened in the interim from May when we were here to today. The proof will show that Ashton, he's 4 years old now, he's done tremendously in a good way. He's gone to school, he's updated with all of his medical needs. He has been adding to his vocabulary, which is great. He's gaining friends, he's very close with his teachers. He's just overall has become healthier. His eating habits are better. And so it's been great for this child since father has taken over the overall decision-making. In contrast, Judge, mother continues to...
The attorney goes for the knockout. She tells the court that since the father took over, the child's life completely turned around: better health, better speech, better behavior. The father's consistency is saving this kid. But get this, the mother's still sending hostile messages and skipping visits. Out of 15 weekends, she showed up only 5 times. The judge leans back, processing it all. You can tell he's thinking, how much longer can this nonsense continue?
Engage in hostile communication with my client. She's making derogatory comments. So mother's visit started February 7 of 2025, every other weekend. So she would have had 15 weekends from that time. Out of the 15 weekends that she was awarded, she only exercised 5. Out of that 5, the last day, she had only exercised 1 overnight because the following day, the children had to be taken to the grandfather's home. The DCS was involved, police was involved, and we'll get to that. So we have the police officer as well, subpoenaed to testify. The very first weekend that mother exercised her visitation on February 7, that was when you found her guilty of contempt because she refused to return the child to the father. February 21 was the second instance of her visitation, the same situation. Refused to return, and my client had to drive 1.5 hours to Tennessee to pick up. And so that was another contempt finding. And then she visited May 30. She was late.
And just when you think it can't get crazier, it does. The attorney recalls the August 8th visit that ended in disaster. DCS and the police got called after reports of abuse and neglect. Dirty house, unsafe environment, and a terrified 12-year-old sister named Sophie. The father had to leave his vacation to rescue his child. Guys, this isn't drama, this is heartbreak in real life. You can hear gasps from the courtroom. The judge's patience is gone. This case is spiraling fast.
But my client accommodated. It was supposed to be 4 p.m., but she came at 6:30. And then the next one was June 13, and then the last episode was August 8. And August 8 was the day when the DCS and the police were involved in the situation. The proof will show that August the 9th, Saturday, the Department of Children's Services were called. There was an anonymous call put in. Apparently, Sophie, the 12-year-old, who is the other daughter of Ms. Hewitt, had made some complaints of abuse. There was some Adderall situation there that will come out in the proof. The environment itself was, the house was unkept, and we will have photos to show of that. There was some environmental neglect allegations. And so it resulted in the children being taken to the grandpa's home. And then my client got a call from the Dixon Police Department asking him to pick up the child. And so my client had to drive again. He was on vacation at that time on a Saturday to pick up his child. So the visitation was cut short. All throughout, from February to today, Mom.
All right, guys, brace yourselves. The attorney lays out more. She says since February, the mom hasn't once checked on her son. No calls, no messages, no effort. Meanwhile, the father keeps accommodating her every time. The judge's face says it all, total disappointment. The attorney finishes strong, describing the father as steady, loving, and responsible. The crowd knows that this isn't a custody fight anymore. It's a rescue mission for a child who deserves peace.
Never checked on the child, never sends any message to dad what's going on with Ashton. Maybe she doesn't have a ride to pick up, but doesn't even initiate any video calls whatsoever. In contrast, my client has been cooperative, bending over backwards to accommodate Ms. Hewitt. And so, Judge, we do have a lot of concern. And the other thing is the diet that's being fed to Ashton. It's going to come out as well in the proof. And so I know that it is very drastic, but in our proposed permanent parenting plan, of course, we were asking that Mr. Fenton remains the PRP with exclusive decision-making. He's doing a great job. Our concern is Ashton. If he continues to stay in this environment, the environment is not healthy, and we'll show the photos. And the other things, the situation with Sophie, it appears that Sophie has been tasked to take care of Ashton every time Ashton is there, and mother just does not participate. My client is asking that mother's visitation just occur in the county where he lives right now instead of overnight, unless...
The attorney brings out the big argument, the child's diet and home conditions. Photos are ready. She insists the environment is dangerous, Sophie's forced to play caretaker, and the mother's neglect is off the charts. The courtroom's quiet, you could hear a pin drop. Everyone's realizing this mother may have weaponized her child's supposed illnesses. The attorney's tone is fierce. We're not here for games. We're here for justice. Guys, that line hits like thunder.
Miss Hewitt can show otherwise that she's fit and capable. And we're asking Friday from 5 p.m. to 8 p.m., Saturday and Sunday 8 a.m. to 6 p.m. And these are the same schedule that Mr. Fenton had when he had to come here. So I feel like it's only fair that she gets the same. And we're asking that mother is to pick up and drop off from Mr. Fenton's home. We ask that applies day to day. And then for the summer, my client is asking that he gets at least 2 consecutive weeks for the first and second months of the summer. If the child support is assessed against the mother, which I believe it will when I calculated it, I do not have credible evidence of Miss Hewitt's income, just because I've not received any discovery responses that I propounded, whether she was pro se and whether she was represented. And so we would ask that the income be imputed per the child support regulation. However, Ms. Fenton does acknowledge that Ms. Hewitt will incur travel expenses, and he wants her to see the child. And so he is willing to waive whatever child support, if any, is assessed against Ms.
The attorney wraps up her case, demanding no overnight visits for the mother until she proves she's fit. The father's willing to handle travel, waive child support, even provide insurance just to protect his child. That's when the judge finally looks up and says, "Thank you, counsel." You can tell he respects her precision. But now it's the mother's turn, and everyone braces. The tension? Electric. You know something wild's about to happen.
Hewitt. He will provide the insurance. He will continue to do that. And then we're asking that he claims him for the tax purposes. So in summary, Judge, we're asking if we apply the best interest factors here. It's truly unfortunate that we had come to this point. We were hoping that things will get better, but instead it got worse. And so we're asking that when the court applies the best interest, it finds that majority of them favors my client and that he remains the PRP and that no overnight visitations be awarded to this unit at this point. That's what I have, Judge. Thank you.
Ms. Hewitt, you are representing yourself, your prior attorney having withdrawn. You have the right to make an opening statement, but I'm going to give you a chance to testify. Do you want to just reserve what you want to say when you testify?
I would like to get a few things straight.
All right, then come on up to the podium and you can tell me whatever you want. This opening statement is not evidence. The evidence will be presented in the form of testimony, but I'll give you a chance to respond to what Ms. Hendrickson has said.
Ashton was never.
All right, guys, this is where it flips. The mother representing herself walks to the podium, shaky but defiant. She claims she has proof, attendance sheets, EAPS, therapy notes. She insists there were no gaps in care and that everything the attorney said was exaggerated. But her tone, defensive, emotional, and scattered. The judge listens, expression blank, letting her dig her own hole. The contrast between her chaos and the father's order couldn't be clearer.
Out of school, or I've got his schoolwork, his attendance, his IEPs, everything, his doctor's appointments. Now his cardiologist switched to different companies. So we were in the process of switching from Dr. Bruns's pediatrics cardiology to another one. But I've got all his school, I've got his school pictures. He was getting ABA, physical therapy, occupational therapy, everything, every day. In TEIS from birth, there was never a gap, except when I switched from TEIS to the Dixon County Board of Education. And I mean, there wasn't like a month lapse or a week, or we just switched.
Now, you have your daughter here to testify. She's not going to testify because she's in the courtroom. Why do you have her here to sit in and listen to the testimony that's going to be presented?
She wanted to come for.
Do you think it's in her best interest for her to listen to the things that you've heard, Ms. Hendrickson, what she says that they're going to present?
Then comes a shocking moment. The judge realizes her 12-year-old daughter, Sophie, is sitting inside the courtroom, listening to everything. He stops everything. Do you really think it's in her best interest to hear this? The mom freezes. The air is thick with silence. The judge orders Sophie to step outside, his voice firm but calm. Guys, this is what accountability looks like: a judge protecting a child when the parent won't. The mom looks lost as her daughter leaves.